For judgment, item number 1.
My lord, may I mention item number 9? My
Just
lord.
a minute, just a minute. I'm pronouncing a judgment.
Yes, my lord. Okay. So, okay.
Okay. Just the operative portion, the impugned judgment, an order is set aside. And the official respondents are directed to bring the advertisement dated so and so to its logical conclusion. And the appeal is allowed. Then pending IAS are also disposed of, and whatever orders have been passed in the IAS will stand merged with this order.
Because the order of land use tax has been reportedly achieved.
Okay. Yes. Item 15.
I received instruction. We are paid, I think we said.
15.
One party.
Mr. C.T. Jamil appears. Item 15,
This one.
have you organized your vakalatnama in the process? Government wants to file affidavit. Okay, your good name, please?
We also-
Mr. Aliba so-and-so, learned counsel for the petitioner submits that he may be granted. How much time? Vakalatnama? 3 weeks.
It's 9.
3 weeks, further 3 weeks time to file the vakalatnama of the petitioners he represents, since they number as many as 990 in total. To stop, Mr. L.T. Sanktam, learned additional advocate general appearing for the state, also submits that he may be granted 3 weeks time to file counter affidavit. What about CGSC? Anyone? Any prayer? Similarly, Mr. C from learned counsel appearing for Mr. Gauhati, learned CGC, prays for some time to file counter affidavit. Next para in view of above. Matter stands adjourned to be listed again after 3 weeks. To stop, the petitioner's counsel shall file his vakalatnama in the meantime, and the respondents shall file their counter affidavit as well. Okay.
My lord, may I mention it?
Yes, what do you want to mention?
My lord, may I mention item number 9? My lord, I am representing RCI, respondent number 4. My lord, I am seeking 2 weeks time. I already dispatched my wakalatnama and counter, but not received yet.
You are for which party? The petitioner?
No, respondent number 4,
Okay.
RCI,
RCI. What is RCI?
Rehabilitation Council of India.
Okay. Your good name, please?
Seema Patnaha, SEEMAPATNAHA.
Miss S. Patana, learned counsel appearing for respondent number 4, submits that she may be granted. How much time?
2 weeks. My lord.
Appearing through RBC, submits that she may
No,
be granted.
yes. Yes.
RBC means regular, this thing,
Yes.
what you call remote video conferencing.
Remote, yes, my lord.
Appearing through RBC, prays for 2 weeks time to file a counter affidavit of respondent number 4. Yes, anyone appearing for the others? Yes. You are for number 3. Yes, and what is your prayer? Mr. Anangami, learned government advocate appearing for respondent numbers 1, 2, and 3. 1, 2, and 5 submits that counter affidavit has already been filed by the respondents he represents. Stop. Similarly, Miss K. Kire, learned counsel appearing for respondent number 3, also submits that affidavit has already been filed by respondent number 3. Petitioner? Okay. Considering the above, matter stands adjourned for 2 weeks to enable the respondent RCI to file the counter affidavit. Petitioner is also at liberty to file a rejoinder affidavit in the meantime as well. Release the matter again after the summer vacation. All right.
Much obliged.
Okay. Yes. You are respondent number 7. How much time?
Maybe after the break.
Yes, any objection? Mr. I. Limatoshi, learned. Oh, you are James. Then who's Limatoshi? He's also there for respondent number 7.
Correct.
Mr. James Newmy, learned counsel for respondent number 7, prays for errors granted further 3 weeks time to file counter affidavit. List again after the summer vacation. Interim order passed earlier shall continue in the meantime till the next date. Yes. Item 4. Yes, you are for the petitioner. Rejoinder not filed. 3 weeks. You have a good name? It's not there in your cost list. Okay, learned counsel for the petitioner prays for and is granted further 3 weeks time to file rejoinder affidavit. List again after the summer vacation. Similar order, item 5. In item 5, one more line, interim order passed earlier shall continue to the next date of listing. Okay, you want me to record your name? What is your name? Mr. N. Chishi, Learned Counsel, appears for respondent number 2 and 3. This is item 5, okay? All right. Next. Item 13. You're for respondent number 1. Who is appearing for 4 to 6? You have also not filed. Okay. Learned Counsel is appearing for respondent numbers 1, 4 to 6. Submit that they may be granted further 3 weeks' time to file their counter affidavit. To stop the praise not opposed to by the Learned Counsel for the opposite party. List again after the ensuing summer vacation. The respondents concerned shall file their affidavit by the next date. Okay.
Similar period in item number 8 for respondent number 1.
Item number 8.
18.
Oh, 18. 18, what is the matter? You want time for filing counter affidavit? How much time? Okay. Any objection? Mr. C. Pom, Learned Counsel appearing on behalf of Mr. Gauhati, Learned CGC, who represents the Respondent Union of India, prays for and is granted further 3 weeks' time to file counter affidavit. To stop, it is further seen that the respondent number 8 has not been served notice, although the same had been dispatched. Registry shall therefore track the postal consignment and put up a note by the next date. List again after the ensuing summer vacation. One more line, Mr. Mo Jamir, Learned Counsel appears for the petitioner. Okay. Item number 2, you appear for? Let me see. Who's for the petitioner? Fakin Richabo is absent. Any objection? You're not appearing, but why your name is there in the cause list? You were there only, you were engaged only for motion. What kind of engagement is that? Okay, anyway, on the joint, the parties are represented by the respective councils and they submit that the pleadings are complete and the matter may be posted for admission hearing after the ensuing summer vacation. Stop as paid for, list again on after the summer vacation for admission hearing on a date to be fixed by the registry. All right. Petitioner, why? What difficulty is there? Toshi Temjen Pongana. Yes. Any objection? You are for the private respondent. You got the benefit of the appointment, land donation. You are not landowner, but you got the appointment. So I think government advocate was required to get instructions. Not affidavit. Was there any advertisement or not? No advertisement. How did you appoint that private respondent then? Okay. Okay. Anyway, since they want time, so we'll give them time. Mention has been made on behalf of Mr. T. Ponganar, Learned Counsel for the petitioner, to the effect that he has some personal difficulties to appear before the court today. Stop. Not stop, and therefore the matter may be adjourned and be listed again after the ensuing summer vacation. Stop. The said prayers are opposed to by the learned government advocate and the learned counsel for the private respondent. In view of above, list again after the summer vacation on a date to be fixed by the registry. Okay. Yeah. Six. There's no counter affidavit.
Yes,
Also, we need to receive a copy of the approval.
He has not filed. I've seen the file. That's why I'm telling you. Who is the appearing? You said Achumi. Government advocate. What's the full name? Miss A. Sanktam. No, Miss A. Sanktam, learned government advocate, appearing for the state respondents, is said to have some personal difficulties to appear before the court today, and therefore a prayer for adjournment has been made on our behalf by Miss Pichano, learned government advocate. To stop, the prayer is not opposed to by the other side. In view of above, list again after the ensuing summer vacation. The state respondents shall file their counter affidavit on or before the next date. All right.
Okay, sir.
Just tell her she has not filed counter affidavit. Yes. Team song. Okay. The counter affidavit on behalf of the state is said to be under preparation. And Mr. Im Song, learned additional AG, appears on behalf of the state as per the submission of Ms. Pichano, learned government advocate. Stop. She therefore submits that matter may be listed again after the summer vacation. And in the meantime, the state respondents will file their counter affidavit. The said prayer is not opposed to by the learned counsels appearing for the petitioners. In view of above, not S, without S, petitioner. In view of above, list again after the summer vacation on a date to be fixed by the registry. The said respondent shall file their counter affidavit by the next date. Stop. Interim order passed early shall continue till the next date of listing. Okay.
That is all there. First, I will mention, ID number here.
12. You are for the petitioner.
Yes.
When are you going to file your rejoinder?
We are, looking for additional,
So how much time? 3 weeks. Your good name?
I'm appearing on behalf of my.
Okay. On the prayer of the learned counsel for the petitioner, a further 3 weeks time is granted to file rejoinder affidavit. List again after the ensuing summer vacation on a date to be fixed by the registry. Mr. N. Angami, learned government advocate, appears for the state. Okay.
Item 19 and 20. Which is here, we have to amend the prayer. Which this matter relates to their compensation of the fee. We have the base of their local act, and this is by the. What is the situation where is there to long to be also advice? So we think that the quality. We are saying it comes from the. So it's really allowed to file an application for the it's very.
That's entirely up to you. No permission is required for filing application for amendment. And perhaps you have also circulated adjournment slip.
Yes.
18, 19 and 20, correct? So we'll adjourn it. When? When do you want it? 3 weeks. Correct. Without application, they cannot amend. It's up to them. And I say no permissions required. They may file it. If they file it, we'll consider it. Miss Esther, learned counsel for the petitioner, submits that considering the development on the considering the issue involved and the development which has taken place, comma, the petitioners may require to amend their pleadings. And she therefore submits that the matter may be adjourned so that necessary steps can be taken by the petitioners. She also submits that an adjournment slip has been circulated and the consent of the other side is taken. Ms. V. Shukre, learned additional AG, Nagaland, submits that she has no objection to the prayer for adjournment. In view of above, matter stands adjourned to be listed again after the summer vacation on a date to be fixed by the registrar. Okay.
For motion, item number 23.
Yes, Mr. Mojawa.
What would be petitioner seeking direction police or force for payment of the rent and also of the land which is being occupied by the respondent?
The rent will be assessed under what law? Supposing it is to be assessed,
Yes.
how will it be assessed?
There are some notifications issued by the state government for private lands. In fact, in the year 1987, a notification was issued by the state government that any central government agencies, if they intend to occupy the land, they have to enter an agreement with the state government to execute a lease agreement, but it should not go beyond 50 years. That is the notification issue. Now that has also been acknowledged by the Ministry of Home Affairs. Also, even in the year 1989, the state government has issued certain notifications where the value of rent or the payment of the rate for payment of the rent has been decided, and it has been circulated by the state government. Now, there are similar cases which are pending. In fact, in a case which registered at PPC number 93 of 2025, in this case, the state has undertaken an exercise to survey the land of the petitioner in that petition. Now, when the survey was conducted, the petitioner's land, it was also included in the survey report. Now, the state has filed the additional affidavit by imposing the survey report, and they have imposed a TD report, which maybe a lot of days ago.
You mean to say there's another writ petition pending?
Yes, Lord.
Filed by you?
No, Lord. The similar spirit case, Lord.
Who has filed it?
By the name Mr. Joseph Kikon, Lord. Now, when the survey was conducted, the state government has conducted both the petitioners, the earlier writ petition and the present writ petition, Lord.
No, this is the second round.
No, Lord. This two different writ petitions.
Two different writ petitions.
Yes.
But you are also included in that survey.
My land was also included in that survey, Lord.
Okay, so why don't you implead yourself in that case? It's still pending.
Still pending, Lord.
Then?
The process to make an assessment of the value and release the amount, Lord. And it was conducted in the year 2025.
No, if you are included in the survey, perhaps you are also to be paid some amount.
Yes, Lord.
Then why do you file this writ petition?
The
Huh?
respondents, Lord.
Sorry?
The state respondents, no positive action has been ensued by the state respondents, Lord. On a survey, nothing. Unless such time this on a court was in order, even in the early writ petition, Lord.
What is the stage in that writ petition? 93 of 2025.
2025.
Correct. What is the stage? This is the order.
Yes, Lord, this is the order, Lord. What is 15, Lord? There are findings, the actions.
It's disposed of or what?
Yes.
Was it disposed of?
No, not yet. It is in the process of assessment of the petitioner's land, Lord. But no payment has been made.
No, correct. From what I understand and from what you have submitted, 93 of 2025, similar persons have already sought for a direction for verification of their land,
No.
assessment of the land.
No.
It is being done.
No.
And they have included your land also. Correct.
They have included, yes.
Ah. So why do you have to file a separate writ petition? You can participate in that case, get yourself impleaded.
Assessment is done only in respect of the petition which is pending for the school. Nothing has been taken.
Who has occupied your land?
The assessment.
Which area?
PPMR falls in the Chumugidima district post.
Chumukedama is a district.
It's on the national highway.
Okay. Yes, what do you say?
Followed in the Union of India, they have filed in that because one letter, that is letter 31st January 2026. And in that letter, I have not received any instruction. That is what is given me time of the instruction that what is intended by the state. And the matter will be released.
Okay, that matter will go on at its own pace, but what about this case? Can it be taken up with that case? Since according to Mr. Moh Jamir, the survey has been done, but no assessment in respect of his land.
Yes.
We'll record that and we'll proceed with that matter. When is it likely to be listed, that matter?
After the list.
Okay, and when was it last listed?
But it was this recently, last week. I don't remember the date.
Okay. Heard Mr. Moh Jamir, learned counsel for the petitioner. How many petitioners?
Only one petition.
Or petitioner who submits that by filing this writ petition, the petitioner has sought for a direction to the respondent authorities concerned to verify and pay him rental compensation for unauthorized occupation of his land falling in within the district of Chumukedima. Stop. He submits that the same has been occupied by the Assam Rifles since when?
1986.
Since the year 1986, without any sort of compensation to him. Stop. The learned counsel further submits that a similar writ petition is pending before this court, namely WPC number 93 of 2025, wherein the respondent authorities concerned have undertaken a survey and verification. And apparently it so happens that the land of the petitioner is also included in the said survey and verification. So, however, no assessment has been made in respect of the petitioner. In respect of the petitioner's land. And therefore, the instant petitioner, having no option, has filed the instant writ petition, seeking suitable direction. Stop. In view of above, issue notice of motion returnable by 4 weeks.
To the
I accepted notice for responding 1 to 3 and 4.
You are saying something?
of the fixed 93 is listed, it's on 20th of November.
Returnable by 20th of July 2026. Mr. C. Form, learned counsel, accepts notice on behalf of Mr. Gauhati, learned CGC, who represents the respondent numbers 1, 2, 3, and 4. We'll stop. Mr. E. Tiwa Form, learned government advocate, accepts notice on behalf of the remaining respondents, that is respondent numbers 5, 6, and 7. To stop. Therefore, notice is complete upon the respondents. Petitioner shall, however, furnish requisite copies of the writ petition to the learned counsels appearing for the respondents today within 2 working days, if not already done. List the matter along with WPC number 93 of 2025. Should I make that date for returnable date? Is it required? Returnable by, I said 20, isn't it?
Yes, sir.
Today is 1, 2. Don't give a date, just say returnable by 4 weeks. Last part will be list again with WPC number 93 of 2025.
For admission, item number 1.
received the status update on the petitioner's case. It can be dismissed after the
Yes. Okay. What is that regularization thing as per the OM? Which OM is that? Can you just show me? Page? What does it provide? Is it page 16? Scheme for regularization and absorption of work charge and casual employees. Please write, Ms. A. Ayumi, learned government advocate appearing for the state, submits that the process of regularization of the petitioners is still an ongoing process. And therefore, she requires some more time to inform the court about the up-to-date status. Stop. She therefore prays for further 3 weeks' time to receive instructions in the matter. Stop. The said prayer is not opposed to by the learned counsel for the petitioner. In view of above, list again after the ensuing summer vacation on a date to be fixed by the registry. Ms. AIME, learned government advocate, shall be ready with the instructions by the next date.
For admission, item number 3.
Yes. Sir Tompo.
Case pertains to excommunication from the village.
Have you filed your reply?
Oh, there is no need for the reply.
But time was sought for last time. That's why I'm asking you.
There is no.
Mm,
Never been that.
mm.
And if they not necessarily.
So I'll record that. We'll fix it for hearing, admission hearing. Mr. Tompo Konana, learned counsel for the petitioner, submits that upon perusal of the counter affidavit filed by the private respondents, the petitioner will not be filing a rejoinder affidavit to the same. Stop. He submits that the matter may be posted for admission hearing on a convenient date. The Mr. Mojami, learned counsel, appears for respondent numbers 5, not 6. 5 and 7, and Miss Lucino, learned counsel, appears for respondent number 6, and they have no objection to the prayer. In view of above, when do you want it? Any date or after vacation? In view of above, list the matter for admission hearing after the summer vacation on a date to be fixed by the registry.
For admission, item number 8.
Links complete.
Yes.
So, are you all ready?
Yes.
Okay, what is the matter?
Sure, it's prohibition the year 1994. And she served under the Department of PWT under the establishment of executive union. And she served for about 30 years. When the time for regularization came, she was served with the shortest notice. Thereafter, she was terminated from service.
Where's the impugn order?
The impugn order is in page number 60,
60. 60.
60, and it should be free. But before that, your order, the short of notice is on page number 58.
Okay, just a minute. 60.
60.
This is a termination order.
Yes, your Lord.
There are 2 persons, isn't it? You are which one?
Number 2.
Okay. Why you are terminated like that?
Because that's pretty short of notice, which I'm in page number 58. The reason assigned is that my service after verification was found to be irregular and falls under any subcategory. Any subcategory.
What is that? Any?
No.
N. N means what?
That I do not have any. No reason was assigned and no explanation was given why my service is irregular and why I is under any subcategory. Only the statement have been mentioned in short notice.
Show cause notice is 5th October 2024.
Yes,
Termination is 6th November
yes.
2024.
After show cause notice, I filed my complaint.
Yes, you were working as
Money.
Mali. On what basis? Work charge.
Road charge. That was even still paid for. My agreement always in page number 27 project. An actual one page. It's a
What are you saying?
my agreement always in page number 27.
That I've seen. This is dated October 19 October 1994. Interest of public is appointed as WC Mali in the scale of pay of so and so. So you are appointed a scale of pay
Yes,
with allowances and temporary liability terminated,
thereafter my service have been periodically,
extended.
yes, extended, verified, and found genuine, and has been periodically.
No, this initial appointment, does it give any time limit for your appointment? It only says you are work charge.
Yes,
So as per the show cause notice, it says that your service is irregular, found to be
Yes.
irregular, and falls under the N subcategory. There must be some explanation for that.
Problem will be of this position test.
They have filed counter affidavit.
Yes,
Have they clarified?
they have mentioned that my name in my Aadhaar, some details in my Aadhaar,
Well,
and the details in the PIMS does not take
details in the,
PIMS. PIMS is
what is PIMS?
PIMS is a it's a system where personal information management system cell.
Okay.
Where all the details of the employees are recorded.
Who generates that PIMS? Who generates that?
PNAR department.
PNAR.
Yes.
Okay.
The department are supposed to,
So your name doesn't tally with your Aadhaar card.
my Aadhaar cards, the details in my Aadhaar card does not tally the entry made in the PIMS.
PIMS.
Yes, Your Honor. But the entry to be made in the PIMS are the responsibility of the department. of The employee. Your Honor.
You have submitted your Aadhaar
Yes,
Aadhaar card. At when did you submit?
Lordship, every time when verification would be done, I've been submitting my documents, not only Aadhaar, but along with other documents, Aadhaar, PAN card, driving passport, all these, Your Lordship. In fact, Your Lordship, if I may take Your Lordship to page number 28, there in the service book, in serial number 3, father's name and within the bracket, and also husband's name in the case of a women, common servant, and residence. So let Tom Tiki, this is the name of my husband, Your Lordship. But later on, when the entry was made in the names, my late husband's name was made as the name of my father. And that the entry has been made by the department's profession.
So that was your explanation against the show cause.
In the show cause, they did not assign why my service is irregular or why I was placed under any subcategory, but I provided all my actual details along with my documents.
Okay, but now why are you saying that it was wrongly entered as your father's name instead of your husband's name?
Because that's true.
Anybody has questioned you on that count?
In some documents, we found. We also, may I take you to page number 43, where a verification list, a letter for verification list was submitted by the Deputy Commissioner and Chairman, district level verification committee to the.
Page 43.
Page 43, Your Lordship.
Verification done by?
Verification by the district level verification committee. And this is as per the government direction. District level verification committee is to be instituted in every district, headed by the deputy commissioner as chairman in the project.
So you also included here.
Yes, Your Lordship. And my name has been placed under serial number 10, Your Lordship. It's in page number 46.
Page number 46. What does it say? Remarks?
In page number 46, serial number 10, my name is Sean, where in PIMS, the third column, that is the details entered in the PIMS, and the fifth column is the details entered in the Aadhaar. So my name in the PIMS has been entered as Sri Susam Tikir, and my actual name is Sunong Tikir, which is in my Aadhaar. And in the next column, my date of birth has been entered at 6 April 1973. Whereas in my Aadhaar, it's 4 March 1973. Thereafter, in the next column, my father's name has been entered as Tom Mong, which is my late husband's name. And in my Aadhaar, it is Thomas Singh.
That's your father
Yes, Your Lordship.
in Aadhaar.
Yes.
What is the full form of PIMS? Personal something?
Personal
Information
management.
Management system.
Yes.
Okay.
Your Lordship, in the last column, in the remark portion, Your Lordship, name, date of birth, father's name to be corrected in PIMS, date of birth 1910-1990, date of appointment 1910-1994. So as per the remark, these are to be corrected. This has been shown in the verification list.
They are to be corrected.
Yes, Your Lordship. Accordingly, I have submitted my documents.
Date of what? DOA
Date of appointment.
or date of appointment? So do you mean to say that the district scrutiny committee, verification committee, recommended that in view of the in difference of names, your name should be corrected?
Yes, Your Lordship. This is shown in there.
So as per the verification, they said it should be corrected.
Yes.
Instead, you were given show cause.
Yes, in the PIMS, it should be correct.
In the PIMS, it should be corrected. Instead, you were given show cause. But the show cause does not say anything, give anything in details. It just says that it was found to be irregular.
Yes, Your Lordship.
And falls under N subcategory. So some categorization is also there. What is N categorization?
Your Lordship, because of the cryptic nature and the vague nature of the show cause notice, we could not give an effective reply.
So what is your reply? Let us see.
It's in page number 59.
Yes, read. Please read it.
With due respect, I have the honor to submit the reply of show cause notice served to me by your office show cause notice so-and-so, dated so-and-so. Sir, I was appointed by the office number so-and-so, dated so-and-so, and posted under PWD Housing Gift Free section. My official name is Srimati Tsunong Tikir, as mentioned in my appointment order. However, my name has been wrongly entered as Sri Tsusam Tikir, PWD 13143 in PIMS portal. Sri Tong Nong is my husband's name, as mentioned as in the PIMS portal. I was placed under B category and attended the physical verification before the committee, which the committee verified my original appointment order and appended signature with seal by the DC Chairman District Level Verification Committee and closed with ballot. Necessary particulars are as stated below. Name, Srimati Tsunong Tikir, employment for PWD 13143. Father's name, Sri Thomas Tikir. Husband's name, Sri Kohima, mentioned as father's name in the PIMS. Date of birth, 4/3/1973, mentioned as 6/4/1973 rupees. Date of joining, 19/10/1994. In support of the above statement made above, I would like to state that I have been performing duties with sincerity and dedication from the date of my appointment. Therefore, I request your esteemed authority to kindly look into the matter and consider the genuineness of my appointment, for which act of kindness I shall remain grateful to you.
What is this employment code number?
once the details of the employees are entered into PIMS.
in the PIMS.
PIMS, yes.
Then this code number is
This code
given. Then in the your original appointment order, your name is there, correct?
Yes, sir.
Apart from your name, nobody's name is there, your husband or your father.
In the appointment. But in my service book, when it was constructed, some videos are in
Where's that service book? This is page 28.
page 3.
So this is in order. Late
Like
Tangbong Dikir husband,
Yes,
father's name, and also husband name in the case of woman government servant. So it is not possible for the person entering the details in PIMS
yes,
to know whether this late so and so is your husband or your father, because the column says father's name. Then in the bracket also husband names in case of woman.
yes. These details are entered by the department.
Correct. Even the service book.
Yes,
They should have written wife of, isn't it?
yes.
Wife of late so and so. Then there wouldn't have been any mistake. Then any other discrepancies?
Yes, besides that, my date of birth in serial number 6,
Is written as
4/6/1973, which
Any-
is supposed to be 4/4 March.
4th March.
The
How?
year is correct.
No, how would you say it should be 4/3?
As per the document is
Which document?
in my Aadhaar document.
No, your Aadhaar is something else. See, this is a service book entry.
Yes,
4/6/1973 has been entered on the basis of your declaration and on the basis of maybe some documents which you have produced. How can you change this to now 4/3/1973? That's a different issue altogether.
the lordship did have been rectified while I was already employed and in the government ID, all these details have been rectified.
Rectified as what?
Lordship in may I take you to page number 3. A government ID was issued to me.
Rectified as?
And my name, my father's name, my appointment date. All these have been rectified in Lordship. Date of birth has also been rectified. My name has been entered as Sunam Tikir, which is correct. Father's name, Thomas Tikir, which is correct in Lordship. Post health Mali. Date of appointment is also correct in Lordship. Date of
This is ID card, isn't it?
Yeah.
Identity card.
this has been provided to me by the department.
But ID card is what? It has to be based on some document. What is that document? Your service book doesn't say that 4/6/2019 is your date of birth. So from where they have prepared your ID card?
Lordship, some of the documents on which all these details are being.
What I'm saying is that one has to base on your service book. ID cards are issued, validity 5 years, 10 years. Again, they'll renew, they'll give you a fresh one. But that has to be based on certain document, and the most reliable document would be your service book. Now, in case of the state, I think you have that PIMS. So what is entered in the PIMS would be relevant. Now, if some mistake is committed while entering the PIMS, and if it is not your fault, then they have to make the rectification.
Because of the documents which I have been relying are next in page number 63, which is my PAN card. Page number 64, which is my indigenous inheritance.
Issued when? When was it issued?
Lordship, for the PAN card, the date of year of issue will not be mentioned.
So it cannot be, at any rate, it cannot be in the year 1994. Correct?
Yes, Your Lord. However, my understanding, the government ID, all the rectifications in the government ID must have been done after relying on this documents Lordship submitted by the petitioner.
This service book is still available.
It should be the department. But the relevant page, I have annexed here. Your Lordship,
If you were not terminated, you will be having service up till which year? 73 born. Date of age of retirement is what, 60 years?
yes, Your Lordship.
60,
My service will have ended in 2029.
2029. 2029 June.
October.
Why October?
I was appointed in the month of October, 1994.
Oh, it's not that. Your date of birth is more relevant, not your date of appointment. Your date of birth, according to you, is 4/3/1973. Correct?
Yes, Your Lordship.
Service book says 4/6/1973. So you have to retire either in the month of February or in the month of March or in the month of June.
Yes, Your Lordship.
October, why do you say October? You're saying that because you were appointed in October.
Yes.
It is not like that.
Yes.
So, the basic case is that you are appointed and then one fine day you get a notice, you reply to the notice and you're terminated. And the reason behind is that there was some recording done in the PIMS, which did not tally with your Aadhaar card.
Your Lordship, may I also plead that periodically my service has been verified. And this verification details
Where is that?
in my service book, which I have annexed in page number.
Okay, just a minute. Before that, this verification, why is it necessary? This is for regularization. I see. Okay, verification is to be done as per what provision? What is the provision?
Lordship, the affidavit in opposition filed by the government responding to Lordship, we have annexed one notification, which is in page number 22, annex 9.
Page number 22
Page number,
of government affidavit.
yes, Your Lordship.
Yes, what is that?
As per this, certain relation has been given. In what manner the verification will be done, who should be conducted? May I read forth?
Yes,
In order to identify and verify the purpose of the category.
just a minute. I don't think I got the page.
Your Lordship, in affidavit in opposition
Filed by?
by the government.
No, respondent 1 to 8.
Yes,
Page 22 is annexure C in my copy.
The last page 27, the next G.
Page 27. Okay, type copy. Please read. I got it.
in order to identify and verify the reviews of the category B, C, and D work charge employees under the Nagaland Public Works Department, the district verification committee is hereby constituted in the following members, with the following members: Deputy Commissioner of respective districts chairman, representative from district police department member, additional chief engineer of respective member, additional chief engineer housing mechanical member, superintendent engineer NH Kohima member, executive engineer of respective divisions member secretary. Terms of references. The committee will verify the authenticity of the employees of the following categories. Category B, spelling mistake of employee's name, father's name, date of birth, etc. between PIMS and Aadhaar. Category C, difference in names of employees and father's name between Aadhaar and PIMS. Category D, Aadhaar applied but not yet received. The head office shall prepare the list of category B, C, and D employees of each division with all details as received from the divisions and submit to the verification committee. Employees under category B, C, and D shall present themselves in person to the verification committee with the original copies of the appointment order and R. The chairman may enter the subordinates of the district subdivision and constitute subcommittees for the physical verification of the NPWD divisions and subdivisions in consultation with the members of the department. If the verification process is over, the above categories of employees should be directed not to report for duty, but only report as and when the verification committee calls for the same. The verification process should be completed and the report subject within a period of 1 month from the date of issue of this office memorandum. Accordingly, your lordship, my service was verified by the district level committee.
This category here, categorization is A, B, C, D.
Yes, report.
But your show cause says N subcategory. What is this
Here
N?
it's based on the B category.
No, what is N subcategory? Please tell me, Miss IME.
Lordship, as per the order dated 17/3/2020, which says I was arrested together instruction with regard to N category. I have submitted the instruction and has been marked as document X in the report.
Yes, what does it say?
So your lordship, there N category says that where things and others that are completely different, your lordship. Since petitioners report on the field portal and things are now completely different, it was placed in N category. Initially, your lordship, when verification was done, when reports did not tell it, he was asked to submit his application with along with all the relevant documents. But the petitioner never submitted any of those documents, your lordship. Time and again, this was intimated to them, but then petitioner did not submit the necessary documents.
What are those? What documents was required to be furnished to submit it?
Your lordship,
But do you dispute an extra one? His appointment order? Then? Why, like, who's responsible for entry in the PIMS?
your lordship, that be the.
Service book also, he's not entering himself. He will make a declaration that I am aged so and so, and this is my certificate. I'm qualified metric pass or under metric. This is my class 8 certificate. Then officials will enter, make their entry in the documents. He's not responsible for entry. So
The documents were sought for, did not come forward, your lordship.
what documents were sought for? Tell me.
Since his date of birth did not tell me his father's name, did not tell me, and the appointment order was also not correctly entered, so all these documents were required.
The appointment order not correctly entered. What do you mean?
The date of the appointment order, it was supposed to be 19/10/1994, your lordship. So all these documents were sought, but it did not come forward. Once we receive the document, it is forwarded to the PNR department, and the PNR makes the necessary rectifications. So the documents were only collected from the petitioner side. But it was never received, that's why it was noticed and it was placed under N category.
So show me one document wherein you have demanded certain documents from him to be produced. Is that enclosed in your affidavit of position? That these are the documents A, B, C, D, E, which was demanded from him. He failed to produce, so we terminated his service.
Must know, your lordship.
Then how do you say that he failed to produce?
He himself was also admitted, affidavit in reply also.
No, where was it? Where was it communicated to him? Show me.
It's not available or individual from what we should.
That, how do we take that into notice then?
Lordship,
You don't dispute the appointment order. You don't dispute the service book. At some point of time, it has gone here and there because of entries made. Maybe the petitioner himself was responsible also, we don't know. But the fact remains that his appointment appears to be genuine in the year 1994. And just because husband's name is written as his father's name and date of birth doesn't tally, and he has produced some other card like PAN card, which was belatedly made. I don't think PAN card was made in 1994. Usage of PAN card has come lately only, after 2000 so and so. Before millennium, I don't think anybody was into having PAN cards and all that, especially in this part of the country where income tax is not paid. Nobody goes for PAN card.
regarding the query, when we allowed to take attention to one document, Your Lordship. In my petition, page number 54, Annex 18,
Yes.
there is a letter. The subject is submission of WC work chart category R1, R2, and N documents. There is a letter, and thereafter in the next page, there's the list of action where my name is mentioned, Your Lordship. In the next page, Your Lordship, page number 15. Fine. There, my employment of name, designation, Aadhaar, and in the last portion of the document, Your Lordship, furnished list of documents enclosed as per Annex 8. Documents which I have furnished, Your Lordship, they are specifically mentioned, and those documents are Aadhaar, birth certificate, appointment order, Your Lordship. So this clearly indicates that I have submitted my documents, Your Lordship.
This is Annexure 18.
Annex 18 report.
So where's the statement against this Annexure 18? Paragraph? Paragraph 10. What is the response in the counter affidavit against paragraph 10?
Lordship, in big paragraph number 6, Lordship.
Was found to be under N category. The next page.
Lordship, it is paragraph, the last line, Lordship.
N category means data which does not match with Aadhaar and PIMS portal.
To my Aadhaar birth certificate and employment order was furnished, Your Lordship. So that
Your Aadhaar also does not support your case.
it's support the case.
How? Demonstrate.
Because in my Aadhaar, my name is correct.
And where is your Aadhaar card? Show me. Is annexed anywhere? The verification committee also has also recommended for what you call for correction of your name. Name, date of birth, and FN. FN means what? Father's name.
Father's name.
To be corrected in the PIMS. Date of appointment 19/10/1994. 19/10/1994. (19/10/1994). Yes. Where's your Aadhaar card? It looks like you yourself has created the problem, making different declarations. Should be consistent. You don't have an Aadhaar card annexed in any document here?
Well, yes.
Miss IME, why is it not possible to rectify? Oh, 56. Date of birth?
Date of birth is 4th March 1970.
Nah, see. Aadhaar, you've made something else. In your appointment note, in your service book, it is June.
The next document is my birth certificate. There also my date of birth is telling with the Aadhaar. Lordship, but how this details would have been corrected in the Lordship?
If I already placed in the documents.
Birth certificate is 4-3.
Birth certificate.
4-3.
Page number 7. And
Economics and Statistics has issued this. When was it issued? In the year 2020, 2003?
2003.
On what basis?
Because while preparing the documents, certain documents are solved, I'm not know exactly what documents were submitted. But certain
Wapur
documents-
village. Father's name is Tomsu Thikar. Tomusu Thikar. And Tomsu Thikar. Then these documents were submitted
Yes, it was.
by the petitioner,
Yes, it was. This has been-
which was in turn forwarded by the executive engineer to the chief engineer.
Lordship, the respondents are stating that I have not submitted my documents, but as per the these documents prepared by them,
Hmm.
it has been clearly mentioned that these documents were issued.
Okay. Shok has not said many things, but you have replied in so many times. It just says that you are found to be irregular and falls under N subcategory. Now, you say that
Lordship, all those Shoko did not mention in here, in why I was placed in as a regular and why I was placed on the category. But as a preventive measure, I have tried in my capacity to explain
hmm,
in whatever possible way that my details are genuine. And I'm not really the entry to read the things for them. And they specifically in prerogative of the volume. And this is not a case where I have not provided my documents. In fact, my service have been really verified from time to time, where my documents are sought, I submit the documents. I'm just a Mali, so I do not understand the letters or whatever instructions the government have, but whatever verbal confirmation have been provided to me, accordingly I have been filing by the lordship. And currently my service have been verified, and this is also annexed in some of my documents, lordship. May I take your attention to page number 37, lordship.
hmm,
This is my premium order, and the verification remark has been made by a district level verification committee, who is DC. Towards the left bottom of your lordship. There is the remark which mentioned that verified, my premium order is verified.
look, your appointment order is verified
Yes,
by
that is after
when
scrutinizing,
was it verified?
this is in the year 2014 lordship. As for the sign and signature.
Hmm.
Then I was, as per the verification report, I was placed under category B. Thereafter, randomly, I was placed under category N without any explanation, your worship. Your lordship, if I may take your attention to page number 59, your lordship. Here, even in this verification list, my name is placed under serial number 6.
Hmm.
But when we look at the list column remarks,
Hmm.
verified genuine. So my name also falls under verified genuine.
Who has given this?
This is submitted by the verification committee. The names and details are seen in page number 42 project.
Hmm.
At the end of this verifications.
Hmm.
The DC and chairman of the verification committee and other members.
You're at serial number
6 project.
6.
Yeah, suddenly. I was placed under N category there. I do not even know what N category was.
What is page 36? Time bound scale
Yes.
given to you. After 15 years.
Yes.
Number one is your appointment order.
Yes.
Number two is your service book.
Yes.
Then number three is your
This is.
time bound,
Education. Yes.
time bound.
Number three.
Time-
Number three is my government.
No, leaving that behind, government ID contains some other date of birth.
Yeah.
There's some differences. What is the next step for?
These are the verification done by the subdivision officer.
This is a part of your service book.
Yes, sir. So my, that been specified by the APO for an entity.
Hmm. Then followed by, let us come to page 36, 15 years. Then 37 also verified. This is done by the district level verification committee.
Yes.
Then summary report. Summary report is there. Then submission of verification lists. Out here, some discrepancy was found. And accordingly, it was said that there should be a correction. Correction should be done. Hmm. What is annexure 15, page 51?
Lordship, this is an application for revision of my.
Revision of your pay.
Yes.
Okay.
Application submitted by the petitioner. The Lordship, the next page is particular letter is also important, Lordship.
Hmm? Page?
Page 50 to be Lordship.
Yes.
After my submission of my application.
It was forwarded.
Yes, it was forwarded, but in the letter, the Lordship,
Hmm.
it has been mentioned in the body letter, it has been mentioned that as per verification report, the employee can, it says also can mention in the letter itself, Lordship. And page 53 is my basic, I have received my salary in the month of June 2021.
Twenty 21.
Yeah, I have not received any salary.
You were terminated from 24.
24.
22, 23, 24, you did not work or what?
I was working in the Lordship.
Where's the date here? Page 53. This is for the month of June.
Yes, your Lordship.
Okay, where is your name?
My name is in serial number 4.
You were given pay up till June
Yeah, June
of 2021.
Yes. And since we did not receive salary thereafter,
Then what do you do?
the petitioner along with other employees who are facing similar situation approached the association. There is a work chart association. And we have been verbally informed that association has been writing letters to the department. However, there has not been any reply. Still then, the petitioner has been working the lordship sincerely.
Lordship,
Thereafter, in basement of all this is document where
You had furnished, okay, that we have seen already.
I was placed under intent.
Aadhaar card doesn't support your date of birth,
Yes, your lordship.
but your name of father is there.
Yes, your lordship.
But your Aadhaar card is supported by the birth certificate
Yes.
issued to you. Then N category. According to the respondents, N category means data which do not match with the Aadhaar and PIMS portal. What is your prayer in the writ petition?
I would pray that of watching and setting aside the interim show cause notice dated 5 October 2024. Second prayer is to watch and set aside my termination order dated 6/11/2024. And for reinstating me in the service of lordship, with back wages and arrears. And also to consider my regularization since I already completed 30 years as per the scheme set down by the government lordship.
Your appointment was dated 19/10/1994. When did you complete 30 years?
October
2024.
2003.
But 2024, you have been shown the door. November.
My termination, I was already completed 30 years before my termination.
Did you pray for regularization at any point of time?
No, your lordship.
Why?
Just prior to that, I was given short post notice. I did not get sufficient time to pray for an motion.
You got distracted with the show cause notice. You could have said that show cause notice may be withdrawn and I may be regularized. You have not said anything about regularization. But in the writ petition, you have sought for regularization.
Yes, your lordship.
Because admittedly, as on 2024, you have completed 30 years.
Yes.
So that is your case.
Yes.
Any authority you have to rely upon.
I would like to submit the following notification regarding regularization. My case is sent to your notice.
That is, 2 points are there. One is you have to be in the pay scale. One is you have to complete at least minimum 30 years of service continuously. No, without break. So that is the scheme of OM dated 17 March 2015. Anything else is there here in the OM?
For languages we are like to relax people.
Back wages. But that will be subject to verification, supposing we find merit in your case. IME, you wait for your turn. Let him complete. Okay. After this, I'll take a short break. I'll come back and you make your submission. Paragraph, which paragraph?
In
Hmm.
paragraph 13 and 14.
What does it say?
May I read the document?
Yes.
In Dipali Silvasan, the appellant had been employed as a teacher in a primary school run by a trust.
Hmm.
The services of the appellant had been terminated by the management of the school pursuant to an ex parte inquiry proceeding. The school tribunal quashed the termination of the appellant's services and issued a direction for the grant of full back wages. In appeal, the High Court affirmed the view of the tribunal that the termination was illegal, but set aside the direction for grant of back wages. In appeal, a two-judge bench of this court laid down the following principles. The very idea of restoring an employee to a position which he held before dismissal or removal or termination of service implies that the employee will be put in the same position in which he would have been, but for the illegal action taken by the employer. The injury suffered by a person who is dismissed or removed or is otherwise terminated from service cannot easily be measured in terms of money. The reinstatement of such an employee, which is preceded by a finding of the competent judicial, quasi-judicial body or court that the action taken by the employer is ultra vires. The relevant statutory provisions or the principles of natural justice entitles the employee to claim full back wages. If the employer wants to deny back wages to the employee or contest his entitlement to get consequential benefits, then it is for him or her to specifically plead and prove that during the intervening period, the employee was gainfully employed and was getting the same emoluments. The denial of back wages to an employee who has suffered due to an illegal act of the employee would amount to indirectly punishing the employee concerned and rewarding the employer by relieving him of the obligation to pay back wages, including the emoluments. The court laid down the following principles to govern the payment of back wages. In case of wrongful termination of service, reinstatement with continuity of service and back wages under normal rule is the normal rule. The aforesaid rule is subject to the right that while deciding the issue of back wages, the adjudicating authority or the court may take into consideration the length of service of the employee, workman, the nature of misconduct, if any, found proof against the employee, workman, the financial condition of the employer, and similar other factors. Ordinarily, an employee or workman whose services are terminated and who is desirous of getting back wages is required to either plead or at least make a statement before the adjudicating authority or the court of first instance that she was not gainfully employed or was employed on lesser wages. If the employer wants to avoid payment of full back wages, then it has to plead and also lead cogent evidence to prove that the employee workman was gainfully employed and was getting wages equal to the wages she was drawing prior to the termination of service. This is so because it is said below that the burden of proof of the existence of a particular fact lies on the person who makes a positive averment about its existence.
So is it anybody's case that you are gainfully employed,
No, your Lord.
but it is your case that you are not employed?
Yes,
Are you sure?
yes.
Because you are working without pay for 2 years. The last pay was in June 2021. 23, 24, you were terminated in 24.
Yeah.
And how did you,
I'm only a minor. I have no education. I have said in the village, there is no education. I work with when I get the opportunity. That's how I survive the opportunity.
so one is that regularization OM, one is your back wages.
Yes.
Anything else? Okay. I'll come back, Ms. Ayami. How long will you take? Okay.
be allowed to point out the one activity.
Yes. What is that?
Page number 68 of the petition, and it should 30. This is regarding the PINs adoption. Page number 68.
Mm. Yes.
We only the Office Memorandum 2016. The Personal Information Management System PIMS has been inaugurated on 21st April 2016. It is a comprehensive web-enabled personal management system for the state government to address the administrative requirement for managing its employees right from the day of their joining into service till they retire. Teams will help in getting instant access and accurate information about state government employees, including details of transfer and posting details and service history. Availability of timely information is the key to efficient management of service matters of state government employees. Therefore, all departments may adhere to the following instructions with regard to these. Number one, on the basis of the information supplied by the departments, PNAR department has made entries in the PIMS database and generated unique employment codes for each employee. Details of existing employee in PIMS database should be updated continuously on daily basis, including details of service confirmation, posting, promotion, retirement, etc. by the departments. So here we see that the lordship, it is from the information supplied by the department, respective departments, the PNAR department has to make entries in PIMS. Thereafter, your lordship, in the office memorandum, which are next location 70. There is another office memorandum in regard to the PIMS, your lordship. I will be only the relevant portion. Serial number 3. All departments are directed to have a PIMS cell and nodal officer to ensure the timely and correct registration and updating of employee service details such as transfer and posting, promotion, MSCP, upgrading, etc. It is advised that the PIMS cell work with or within the establishment branch of the officer's number 4. Every entry to be made in the service book must also be updated in PIMS. Departments may refer to PNAR or and so dated so regarding guidelines for maintenance of service book. Thereafter, lordship, in the next page, this is most important one, I guess, lordship. Serial number 7, Point number 7. PIMS registration is the responsibility of the department and not the employee consent. So all the details which I have furnished through my documents should have been entered correctly to PIMS by the respective department lordship. That's the department lordship.
Okay. That's it?
Yes.
This time.
Motion is for the OMG to 21 August 2021. This is with regard to the OM regarding the notification to be done. Here,
Where's that OM? Show me.
you might activate the last page, motion, and it's actually page 27.
Yes.
This is with regard to the verification to be conducted. We have the point number 2. It clearly states that till the verification process is over, the above categories of employees should be directed not to report for duty, but only report as and when the verification collective was received. So the organ verification process is started, all board employees were directed not to report for duty.
When was that?
2021, we launched because verification started after this, the qualification was out.
Okay.
So that's why the salaries were paid till June 2021. After that, their salaries will not be negotiated.
But this is August. After June, you have July and August. He was paid till June, July, August. So he stopped coming because of this office memorandum. Now, take a situation, supposing after verification, everything is found to be correct, then he's to report back. Then what happens to his salary? He'll be paid from the date he was stopped coming. In his case, though, he was ultimately 24, he was sent out. And before that, show cause notice also was in the year 2024 only, I think. 5th October 24. Then termination is 6 November, after 1 month. And from 21 August 2021, verification was going on for 3 years. What will happen to their condition? Insofar as petition is concerned, okay, he said that he is not eligible because the documents don't tally. The particulars don't tally, so there is some discrepancy and he has to be terminated. But in respect of those persons who were found to be, documents were to be in proper shape, what will happen to them? Who will pay them? Are you going to say no work, no pay? Okay, that is one point. Then what is the other point?
Was terminated on the candidate and government's function. This was based on the end to be. Now, your lordship, his is not an isolated case, because altogether there are 1,707 employees, no judge employees who are based on the end, then they were all.
Each case will be different. Only petitioners before this court. We are not concerned with others. They may have their own genuine grievances, but they are not before this court. So we cannot also enlarge the scope of this writ petition about others. So far as the petition is concerned, he has said that this is my case. This is what has happened. This is not correct. You don't dispute the fact that the initial appointment order is bad, or it was managed, or it was somehow illegal appointment, or unauthorized appointment, or there was no appointment. That is not your case. Only thing is that some particulars were not matching. And for that reason, he was kept in the N category and ultimately terminated. But he has rendered service for 30 years. Will it be fair at this stage saying that something wrong? Instead of your husband name, your father is said to be your husband. Like that. I mean, all these discrepancies or technical or some errors in the registration of the teams. OM says that it is the responsibility of the department also. So what other documents we require otherwise? He has the appointment order, he has the Aadhaar, he has the birth certificate, and you maintain the service book. You have the verification report. See, thing is that date of birth may change. What is important is the initial date of birth. You must be aware about FR note 6 before FR 56. Is it available in the state? FRSR, Nagaland? Fundamental rules, subsidiary rules, CCS, CCA rules, applicable? So note 6 before FR says that any change in the date of birth has to be done within 5 years of entry into the service. So at the fact end of the service, the person cannot say that, no, my date of birth is this, and gain some more years. It is not permissible. So on that point here, some discrepancy on the date of birth. Initially, his date of birth is supposed to be March in the service book.
I got it's a bit of a place focusing on the state of and the daily 5 years.
That's what is based on FR note 6 note 6 below FR 56. So date of birth, there's no issue. Now we are concerned with termination. Date of birth, you may go with that March only, because what he has declared at the time of service, that has to continue. Unless he has come up within that 5 years and said that, no, this is my matriculation certificate, or this is my certificate, baptismal certificate, which shows that my date of birth is not in March, but in June. Then authority may change. But after 5 years, I don't think there's any compulsion on the part of the authority to change the date of birth. We are not on that. Today we are on termination. I'm just giving a remark on that date of birth thing. Termination. So what we'll do is, I think you'll have to reconsider his case. And you give him a chance to produce all the testimonials which he has in his possession, and you will verify them and accordingly act upon it, taking into account that his initial appointment was done on this date. Everything was done. So there are less chances of you to say no at this stage, in fact. But that freedom will be there for verification. Please write, heard Mr. Z. Chishi, learned counsel for the petitioner, and also Miss A. Ayemi, learned government advocate, appearing for the respondents. The petitioner, by filing this writ petition, has sought for a direction from this court to set aside the show cause notice dated 5/10/2024, bracket annexure 21, and the notification dated 6/11/2024, by which his services as work charge employee has been terminated with immediate effect. The notification will be annexure 23, okay, bracket. Oh, sorry. Did I say he or she like that? He, she, her. Okay. The petitioner has further prayed for a direction to the respondent authorities concerned to pay her back wages and also regularize her into service in terms of the office memorandum dated 17/3/2015, issued by the Government of Nagaland in the Personal and Administrative Reforms Department, bracket, Administrative Reforms Branch. Next paragraph. It is the case of the petitioner that she was appointed as work charge Mali in the scale pay of rupees 800-1475 per month, with all other admissible allowances from time to time. White office order dated 19/10/1994, bracket annexure 1. Stops. Since her appointment into service, the respondent authorities concerned have prepared her service book, entering the details of our particulars, the respondent authorities concerned have also verified her services, and she has continued in her service without break since her appointment. This verification was initiated by which order? Sayani had shown me one document, no, that they should not join and all that. It started with this OM. This is by Works and Housing Department. Is it the nodal department? Or it should be PNAR? Mm. So the petitioner also contends that she has also been receiving the enhanced pay from time to time as fixed by the respondent authorities. Stop. However, pursuant to a certain verification done on the service particulars of work charge employees, the petitioner was served with a show cause notice by the engineering chief NPWD on 5/10/2024. Stating that after verification, our work charge service was found to be irregular and fell under N subcategory, N for Nagaland, within single inverted comma, N subcategory. So accordingly, the notice of termination was served to her. Stop. In response, the petitioner submitted a reply to the said authority on 28/10/2024, stating that she was appointed on work charge basis by order dated 19/10/1994. And she has been serving as such till date. Top. She also stated that there was some discrepancy while making an entry in the personal information. What is that? PIMS full form?
Personal information management system.
Personal Information Management System, bracket PIMS, PIMS, portal. And she, by pointing out the correct particulars, requested that the same may be rectified. Stop. However, the engineer-in-chief, via the impugned notification dated 6/11/2024, terminated her services as work charge employee with immediate effect. Stop. Agree the petitioners before this court. Next para, the learned counsel for the petitioner, Mr. So-and-so, submits that the petitioner was appointed by office order dated 19/10/1994. As work charge employee in scale of pay, and her services have been verified from time to time by the competent authority. Stop. Having rendered 15 years of continuous service, the petitioner was also given time-bound scale of pay by office order dated 21/8/2018. Stop. Prior to that, her initial appointment was also duly verified by the Deputy Commissioner cum Chairman of District Level Verification Committee, Kifri District, Nagaland, on 22/10/2014. Stop. He also submits that where is that discrepancy you are just talking about? I think it's page 43, isn't it? That report regarding rectification to be done.
The first summary is on page 38. And where she was found to you.
No. Come to page 46.
Yes.
What is this column? Susang Tikir and Sunong Tikir.
Here is the name entered in the piece. Next for
Who-
her name should be entered as Sunong to give.
Which one is correct?
Sunong to give is correct. The second one.
Aadhaar. And Susang Tikir is, where is it entered? PIMS.
Means
He further submits that as per the entry made in the PIMS, there is discrepancy in the name of, this is his name or his father's name.
this is her name, and in fact, her gender has also been changed in the piece. It's written Sri instead of Shri.
Okay, this is the petitioner's name, isn't it?
Yes.
What did I say last? There is discrepancy in the name of, there's discrepancies in the entries made with the particulars of the petitioner. The name of the petitioner has been wrongly entered as Sri, isn't it? Sri Susang Tikir. Page 46, okay? Page the sign. Susang Tikir. And what is the next 6 April?
That is the date of birth. The first column for the date of birth is entry made in the piece,
Hmm.
and the second is the entry.
And also in the date of birth of the petitioner, which has been recorded as 6/4/1973. While the date of birth of the petitioner as per the Aadhaar is 4th March.
4th March.
4th March, as per the Aadhaar, is 4th March 1973. And who is this Tombong?
Hong is the entry in the piece as father's name,
Okay,
but the actual father name is Thomas.
okay. Further, there is also discrepancy in the name of her father entered in the PIMS. Stop. The constituted district level verification committee, upon finding such discrepancies, through its chairman, informed the engineer-in-chief, NPWD, on 29/2021 that the name of the petitioner, her date of birth, her father's name be corrected in the PIMS. Date of appointment is okay, isn't it?
Yes, he got.
PIMS. Stop. However, despite the same, the petitioner was served with a show cause notice and thereafter terminated from service. The Learned Counsel submits that the petitioner has rendered continuous service for more than 30 years at the time when she was terminated from service on 6/11/2024. And the respondent authorities, instead of considering regularization of her service, has terminated her from service. Stop. He further submits that the petitioner, despite having rendered her service prior to her termination from service, was paid her salary only up to the month of June 2021. Stop. In this connection, the Learned Counsel has referred to Annexure 17 of the writ petition, which is the pay bill of work charge staff under the Subdivisional Officer, PWD Housing Subdivision, to Ensang, for the month of June 2021, wherein the name of the petitioner appears at serial number 4 with her designation as Mali. Next paragraph. The Learned Counsel further submits that PIMS is a database which is required to be updated continuously on daily basis, and the same includes the details of service confirmation, posting, promotion, retirement, etc., which is to be carried out by the department. So the department has to each department has to have a PIMS cell and a nodal officer to ensure timely and correct registration and updation of the details of the service of its employees. Stop. Such instructions have been circulated from time to time, including White Office Memorandum dated 27/5/2016 and 4/3/2022, amongst others. The bracket. Submitted by the District Verification Committee, headed by the chairman, who is also the Deputy Commissioner of the District of Kipre. The respondent authorities concerned ought to have made the necessary rectification in the PIMS, since the petitioner is not responsible for making such entries, either in the PIMS or in the service book. The next paragraph, Learned Counsel further submits that the petitioner is eligible to be considered for regularization of his service in terms of the office memorandum dated 17/3/2015. In view of the fact that he has rendered more than 30 years of service at the time he was terminated from service, and he was serving continuously on work charge as work charge Mali on scale pay without break. Stop. The Learned Counsel therefore submits that the impugned orders may be set aside and the respondents may be directed to regularize the service of the petitioner in terms of the said office memorandum. Stop. He further submits that since the petitioner has been denied from rendering his service arbitrarily and illegally, she is also entitled to back wages from the month of July 2021 till her reinstatement. Stop. In this connection, the Learned Counsel has relied upon the case of Jayanti Bhai, Rauji Bhai Patel versus Municipal Council, Narkhet and others, reported in 2019, 17 SCC 184. Next paragraph, per contra, Ms. A. IME, Learned Government Advocate, submits that there are certain discrepancies in the service particulars of the petitioner, and for which reason the petitioner was asked to produce the relevant documents. Stop. Since the petitioner has failed to do so, a show cause notice was issued to her, and since the same was not satisfactory, the impugned termination order was issued. Stop. She submits that the petitioner is not the only work charge employee who was not given salary awaiting this verification report. Stop. Referring to the office memorandum dated 21/8/2021, annexed to the counter affidavit as Annexure G, the learned government advocate submits that since a verification had been directed to verify the service of Group C and Group BCD, is it? B also. Group B, C, and D categories. It was provided that till the verification process is over, the said categories of employees were directed not to report for duty, and that they should report for duty only when the verification committee calls for the same. Stop. She submits that since the petitioner has failed to satisfy the respondent authorities as regards to the correctness of our particulars entered in PIMS, the petitioner has been terminated from service, and therefore the same does not call for interference of this court. Next para, I've heard the submissions made by the learned counsels for the rival parties, and I have perused the materials available on record. Stop. The petitioner was appointed as work charge Mali by office order dated 19/10/1994 in the scale of pay of rupees 800-1475 per month with all other admissible allowances. Stop. Admittedly, the petitioner continued as such till she was served with the termination order on 6/11/2024. Stop. It is not the case of the respondent authorities that the appointment of the petitioner was unauthorized, illegal, or doubtful. Stop. Only what has otherwise been projected is that entries made in the PIMS do not tally. Tally with what? Tally with the documents and testimonials produced by the petitioner. Stop. It may be seen that the services of the petitioner was otherwise verified from time to time. in her service book from time to time, and the same entered in her service book. By the respondent authorities concerned. Stop. Not only that, after completion of 15 years of continuous service, she was also given a time-bound scale in terms of the government's order dated 24/7/2018, White Office Order dated 21/8/2018, issued by the Sub-Divisional Officer, PWD-H, Tuensang, Nagaland. Stop. Even in the list of work charge and casual employees in the district of Kifre, which was Kifre for the Department of PWD-Housing, which was verified by the constituted committee. The service particulars of the petitioner was verified and it was found to be genuine. Stop. The petitioner's name finds place at serial number 6 of the list prepared in this regard, and which is annexed as Annexure 12 to the writ petition. Stop. Although the learned government advocate has submitted that the petitioner could not produce the relevant documents to support the entries of our particulars in PIMS, but it is seen that the Deputy Commissioner, where is that forwarding, Mr. Counsel? Is it this annexure 40, page 43? He said it is forwarded.
Page
But it is seen that the executive engineer, PWD-H, Tuensang Division, on 8/3/2022, had forwarded the relevant documents pertaining to the petitioner to the chief engineer, PWD-H, Nagaland, Kohima, which included Aadhaar card, birth certificate, appointments order, etc. Stop. It is true that the date of birth of the petitioner in the Aadhaar card and in the baptismal certificate is shown as 4/3/1973. But what has been entered in her service book otherwise is 4/6/1973. Stop. Stop. As already stated, the respondents have not disputed the genuineness of the appointment order issued to the petitioner by the authority concerned on 19/10/1994, by which she was appointed as work charge Mali in scale of pay. Stop. The discrepancy in the date of birth otherwise can be taken care of in terms of the prevailing rules and regulations. Stop such discrepancy in the considered view of this court cannot be the reason for termination of our service when the initial appointment itself has not been disputed. Stop. There may be other discrepancies in the name of our husband or in the name of our father, which can very well be looked into by the respondent authorities concerned in terms of the recommendation made by the constituted district verification committee. Stop. The learned government advocate has also referred to office memorandum dated 21/8/2021 issued by the government of Nagaland in the Works and Housing Department (Works branch). So paragraph 2 of the said office memorandum indeed provides that till verification process is over, the group B, C, and D categories of employees should not report for duty and should report only when asked to do so. Stop. It is seen that what follows thereafter is that the verification process is required to be completed within a period of 1 month from the date of office memorandum. Stop. Therefore, the office memorandum cannot act as a bar for the petitioner not to report for duty from the issuance of this office memorandum till he was terminated on 6/11/2024. Since the verification process very well exceeded more than 1 month period. Stop. On the other hand, it is the case of the petitioner that she has been rendering her service till she was terminated on 6/11/2024. Stop. Another aspect of the matter is that the office memorandum dated 4/3/2022 issued by the government of Nagaland in the PNRD (PIMS cell) close bracket, that paragraph number 7 of the OM clearly shows that PIMS registration is the responsibility of the department and not the employee concerned. Stop. Likewise, another office memorandum issued on 27/5/2016 by the same department provides that PIMS database should be updated continuously on daily basis, incorporating the details of service of the employees, including confirmation, posting, promotion, retirement, etc. Stop. Therefore, the entry made in PIMS with regard to the details of the petitioner is not a one-time process. Stop. Like all other employees, as provided the office memorandum, it has to be a continuous process. And if any discrepancies are found in the entry, the same can very well be looked into by the department by seeking a clarification with supporting documents from the petitioner. So therefore, when the very appointment of the petitioner has not been questioned, the respondent authorities, in the considered opinion of this court, would not have terminated her service in the manner it was done. Stop accordingly, the impugned show cause notice dated so and so and the termination order dated so and so are hereby set aside.
Termination order in respect of serial number 2.
Yes, you're right, Ms. Ayani. Termination order dated so and so, and show cause notice dated so and so, and termination order dated so and so. You just add, insofar as the petitioner is concerned, are hereby terminated, are set aside. Next, Pera, the apex court in Jayanti Bhai, Raoji Bhai Patel, Supra. While considering the issue of payment of back wages, took into account the decision rendered by the same court earlier in Deepali Gundu Survase versus Kranti Junior Adhyapak Mahavidyalaya, reported in 2013 10 SCC 324. Inflect. Wherein it was held that in case of wrongful termination of service, reinstatement with continuity of service and back wages is the normal rule. Of the same is subject to a rider that while deciding the issue of back wages, the adjudicating authority or the court may take into consideration the length of service of the employee, oblique workman, the nature of misconduct, if any, found proved against the employees / workman, the financial condition of the employee and similar other factors. Have you made any statement that you're not employed anywhere, Mr. Counsel?
Respect of that has to be.
So it was further provided that ordinarily an employee or workman whose services are terminated and who is desirous of getting back wages is required to either lead or at least make a statement before the adjudicating authority or the court of the first instance that he/she was not gainfully employed or was employed on lesser wages. Stop. Likewise, if the employer wants to avoid payment of back wages, it has to plead with cogent evidence that the employee was gainfully employed elsewhere. Next para. In the present case, the petitioner has neither pleaded, the petitioner has not pleaded that he is not gainfully employed elsewhere while seeking for payment of back wages. Stop. Likewise, the respondents have also not, likewise, it is not the case of the respondents as well that the petitioner is gainfully employed after she has been terminated. Stop. Having regard to the fact that the petitioner is a grade 4 employee and was serving on work charge basis, this court is of the considered view that ends of justice would be served if the payment of back wages is limited to 50% of the amount which she would have earned had she been continuously serving. So stop. The direction for payment of the back wages is made considering the fact that the termination of the petition has been interfered with by this court on the ground that the very appointment of the petitioner, while not being disputed, but in view of the discrepancies in the entry in the PIMS, which otherwise was not the responsibility of the petitioner, is found to be justified. Stop. Next paragraph, the respondents are thus directed to reinstate the petitioner. With 50% of our back wages within a period of
The direction will be given to the state to re-examine the petition instead of directly reinstating him. We was having re-examined this issue, I mean, on January.
That is what I said, isn't it? What did I say last? Uh-huh. Hmm. 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 Miss Ayemi, I don't think there's any scope for now verification. We have already directed. Because yeah. Uh, the respondent authorities. No, the petitioner on his part would also be required to produce. You will ask or he'll produce. You'll ask or he'll produce. Who will do that? The documents which you require, should he produce or you'll ask for it?
To me, produce so much along the application. Because in my affidavit, I have clearly simplified the meeting that we did not submit the application along with the required documents. Whereas he claimed that he is submitted. So yes,
The documents clearly specified that.
You submit again.
Yes, sir.
The petitioner, in support of her claim that she has been appointed as work charge Mali and has been working as such ever since her appointment. And in support of her other particulars, shall submit such documents in her power and possession before the which respondent? Before the respondent number 4 and 5, and the said respondents upon 4 and 5 within a period of
That can be, something that can be very long.
within a period of 1 month. No, I think you cancel that part. Okay. This should reinstate, I said, na? The last paragraph before that. What was the last line? Reinstatement. With personal back wages. And in doing so, the respondents would be at liberty to scrutinize, to re-scrutinize and verify the service particulars of the petitioner. So that appropriate rectification can be made in the PIMS in terms of the relevant office memorandums. I have held that you cannot terminate her service in the manner it was done. So reinstatement is there. So, but still then liberty is given to you to scrutinize the thing and correct in the PIMS. I think that should be ordered. Huh? For prayer. On such reinstatement, the services rendered by the petitioner from the date of her initial appointment till her termination, till no, on her reinstatement, the period between the date of termination and the date of reinstatement would not be taken as a break for the purpose of considering the petitioner for regularizing her service in terms of the office memorandum dated 17/3/2015. Stop. The same shall, however, be subject to scrutiny and verification by the respondent authorities concerned in accordance with law and as per the prevailing guidelines in this regard. I'll just fine tune it. That is the order. Okay. With the above observation and direction, the petition stands disposed of.
Let's see, let me see, I don't know sure. My colleague over to the solicitor. I agree.
Which IA?
Made no service.
Just a minute. Huh? This is item 8, isn't it? Item 12. Interim is there. Item 12, just take note. Huh? Interim order passed earlier shall continue to the next date of listing. Item 12. Yes, and what remains now? Eight minutes. How many matters are there? Next item will be 10. Item 10 is there. 17.
I don't know. The last solution I would have to reduce the stars.
We'll come back at 2. There are many other matters also. Okay. At 2.
Mo yete sai zode. I'll check once. For admission, item number 10.
It's this matter was not that or shit, and hearing is almost completed. However, if certain duty was met and the government has been directed to choose the reconstruction order of the great work release. The debate from 1990, which was done well.
Yes. You cannot. So various orders are.
So, ask for this letter lordship.
Let us submit, Mr. Counsel. These are our instructions. Yes, tell us.
Yes, Lordship.
What has happened?
Yes. Lordship. Emotion, if I may belong. School body in the past, first ever this money in what places.
Who's we have to know? Whom are you reading? This one.
Yes,
What is the date of the order? Letter?
yes, sir.
22 June. Where are you reading?
Number 2.
Yes. Please read.
Street body near the was first awarded this money in 1928. Number 3. The agreement was re-approved this sea and water basis point. We found able to verify. His personality in that series would be counted from the date she was re-appointed as policy. In accordance with this memorandum, the review lines report, significantly student then presentations was negative with new structures in place in the police for this for the date of the in that particular presentations and vote test were the date of entry itself.
She was first appointed as Mali on work charge, correct? In 98. Then in 2005, again re-appointed as Khalasi on work charge basis. Then, so seniority of Khalasi would be counted from the appointment as Khalasi. And if you count 2005, she doesn't have 30 years. What are you saying? 15, 25, how many years?
She is certainly 24 years.
24 years.
So Commissioner is not eligible with that sort of this language to 15 and 2004. So 15, she only served 24 years, it must be 3 years to be request. And so for retrospectively, he cannot be the request of she. And the above are the parts who were request.
Work charge means work charge. What is the difference between Mali and Khalasi?
Yeah, these are council.
They are great for posts. Both are great for posts. Are you having a seniority list separately for Khalasi and for separately list for Mali? Then on what basis are you saying that? Then what is the last order?
Yes, 15/6/2026.
Exactly, I know that. I have passed the order, I know. You are supposed to tell me how many people have been regularized since 1998 to 2022. How many? Who are those? These 3 persons.
Yes.
Date of regularization 2003 and 2017. Why only 3 persons?
There was no vacancy, Lordship.
Within a span of 24 years, you could only regularize 3 persons.
Yes, that motion, there is no vacancy.
What is the nature of job of a Khalasi? Khalasi is equal to peon.
Lordship.
Mali is gardener. You don't know. Mali is a Hindi term. I think it's a Urdu or Hindi term. It's Mali means a gardener. Mali. What is this?
That's very base for also the group imposed.
Yes, what is it?
All the grade for boss,
Hmm.
boss are group T as per the discipline task and is multi-tasking stuff.
Hmm.
So there is to get a registration of beyond colors and multi orders. This order is
But- But this OM is dated 2021 only. We want to go back in time. Since 1998. That time there was all separate. Now you call them MTS. MTS includes all these grade 4 posts. You were covered by which OM? Petitioner. You are covered by which OM?
My release for the administration under open popular law.
2004, correct?
As well as president all by the. It's not as well as president.
OM 2004 does not say 30 years, isn't it?
No.
What is the requirement?
Secondly,
What is your seniority position?
that I cannot see.
You have been released, isn't it, already?
Already released here to.
Oh, lordship, it was very, very that, is the level to the board. We want to go to lordship, if I will be able to do. Regularizations of portraiture will be done against every particular vacancy. So if I put the time, they was fully vacancy lordship. The only change also regularize.
Today you are seeking regularization for the purpose of getting pension.
Yes.
Is it? Not to get back into service, but to
No.
get the pension benefit. But then requirement is the vacancy has to be there.
I'll come to that.
This is the problem.
I'll satisfy was, even was vacancy.
Huh?
Before my retirement,
Uh,
there were a lot of vacancies as per the available reports. I'll satisfy was.
the available records means in the rate petition.
No, after filing the petition,
Hmm.
information has to be furnished through the RDI.
But that is not on record, na? You should have brought that on record.
So at the time of filing the petition, that RDI information was not furnished to me.
I'm not saying that.
And subsequently, lordship.
At the time of filing rate petition, you did not have it, not disputed, okay. But later on, you've got the documents. So you should have filed those documents.
By the report furnished by the government by the way. Which you may kindly see, should not the two in sheet.
Hmm.
You were appointed in the year 2005 only, lordship,
And whereas you were appointed on?
1998.
Hmm. Hmm. So what has happened has happened. As of now, I don't think we can reopen and saying that you take them out and consider your case instead. You are to show us as on today if there is any vacancy.
Now I think lordship.
So that is why, na, unless there is a vacancy, we cannot say that you should be. But this contention that earlier he was Mali, now Khalasi, later on Khalasi.
Yes.
Huh?
The next one, there is a verification also. I'm not suppressing the facts of it. I'm still verification there, the paragraph version.
So you have surrendered 24 years of service by taking your appointment as Mali, correct? Both Mali as well as Khalasi. If you add both, it's 24 years.
Yes.
And unlike the other office memorandum, there is no prescription of 30 years. If there is, as per your seniority and as per the vacancy available. So you are to overcome these two hurdles. One is seniority that they'll consider, supposing, and the other one is vacancy. If there's no vacancy, there's no point saying that consider his case. You have to show us that. And what documents you're holding now is regarding vacancy at the time you were superannuated.
Yes.
What has happened to that vacancy?
My GU is pretty colorized.
When?
Just go for your information. And there is this documents. This is the earlier reply finish. This is the 10th, 9/2025. Worship page 3. Another place, where submission is signed, the issue was subsequently updated. This is the order, page 3.
Who is this?
The petitioner, subsequently
Okay.
updated.
2005
Yes, Lordship.
as Khalasi.
There is no display. Come to page 4, Lordship. Number of books charged legal with for English legalized petition from 2005 till 2002 with service. Lordship, still number 5 is genuine the petitioner.
Serial number 5.
Yes. 9, genuine the petitioner. 13, genuine the petitioner. 17, genuine the petitioner. 20, genuine the petitioner. 31, 32, 33, 34, 35, and 36. All this grateful employees who were junior petitioners were recognized.
Lordship, the definitions are
Let me
different.
finish.
Irrigation and flood control, Dimapur Division, Dimapur. This is under the Department of Irrigation and Flood Control.
Yes. State department was.
And this list is for that department only.
This is respect of the department.
Okay, but these are all different places. Mokchung, Chumukedema, Kohima, Pek.
This is under water resources department also.
So question is whether you can be considered for regularization in other place. Where were you posted?
It was posted in Dimapur.
Dimapur. So can you be considered against a post in Mokuchung?
As for the seniority, because in the department, the seniority of all the English should be maintained. As for the seniority of the English.
But then you say that you don't know your seniority position.
Yes,
There is no seniority.
but then as for the reports which I prefer to endorse. 12, report employees, as per the appointment order and regulation, these are all junior commissioners who were regularized before the commissioner was prepared.
Who are they? Tell me again. Serial number?
Number 5,
5, then
9,
9,
13,
13,
17,
17,
20,
20,
31,
31.
32, 33, 34, 35, and 36.
They are junior to you.
Yes, and after the commissioner, after retirement of the commissioner Lordship, from serial number 38 to 48 were regularized, who are junior. 38 to 48 are all junior to petition, however, they were regularized after the retirement of the petition.
They are junior and younger to you also.
Perfect.
They are younger to you also. Because you retired because you crossed the age of 60 years. Correct?
Yes. Roll number 38. The person was appointed in the year 2005 and regularized in the year 2025, last year. From 38 to 48, all the corporate employees were regularized last year. Also.
But your list that you have and the list produced by the learned government advocate,
Yes.
does it tally?
That is in respect of Kalasi only.
Kalasi. And this list
It is not mentioned here.
designation is peon, chainman, daftari.
No Kalasi process mentioned in the chart. Is that British?
So how can it be? This list doesn't tally to each other. Both are of the Water Resources Department. This is by RTI. And it says that list of work charge casual grade 4 employees regularized with effect from 2005 to 2022 with service particulars. So this should invariably include Khalasis also.
Yes, sir.
But there's nobody. Now your instruction now says that these 3 Khalasis are appointed, are regularized. And the year 2003 and 2 of them in 2017. Their names don't find in this list. So there's a separate list. You're maintaining separate list for Khalasi or what?
As per the list, I raised to you, Lordship. It mentioned about grade 4. Grade 4 employees. That includes Kalasi also. Which falls under group D category of employees.
So I think your instruction is incomplete. Which I know. The 4th paragraph, it says, in accordance with OM dated so and so, seniority lists were maintained designation wise. And accordingly, senior most work charge employees in the relevant category was regularized as per date of appointment in that particular designation and not as per date of entry in the service. So petitioner was appointed as Khalasi on work charge basis on 25/8/2025. Where is the seniority list? You have it? And what is the vacancy as on today? Tell us also that. See, are you supposed to regularize only on postwise basis? How can that be? Now you're maintaining this multitasking stuff, MTS. MTS comprises of peon, chokidar, mali, sweeper. Everyone. And whether Khalasi is the term used as on today. Do you have Khalasis as on today in departments? That also you don't know. What? Then? We'll consider this at the relevant time. You tell us what is the vacancy position as on today? And what is the seniority list of Khalasi? Whether the name of the petitioner is there or not. And if it is there, he stands at serial number, at which serial number? This is only to substantiate your instructions. Please write in terms of the last court's order. Ms. Vichano, the government advocate has obtained instructions, which is to the effect that the petitioner's seniority has to be counted only from the date he was appointed as work charge Khalasi, and not as his appointment to the post of Mali. So she submits that between 1998 to 15/12/2022, only 3 persons were regularized in the post of Khalasi. In accordance with the seniority position. Stop. The instruction, however, is silent as to whether is silent about the seniority position of the petitioner compared to the 3 persons who have been regularized. Under the circumstance, the learned government advocate shall obtain further instructions with regard to the seniority list of Khalasis, showing the position of the petitioner vis-a-vis the 3 persons said to have been regularized between 22/8/1998 to 15/12/2022. Stop. Their names are Shri Razovil, Shri Vikeduho Hibo, and Sri Akuta Achumi. These are the names, okay? I've ticked. Then next line, the learned government advocate shall also obtain instructions as regards the vacancy position in the post of Khalasi, and further as to whether the nomenclature Khalasi is still being used as on today. Considering the fact that the post of erstwhile Group D posts of peon, chokidar, mali, and sweeper has been redesignated to that of multitasking staff bracket MTS by office memorandum dated 25/2/2021 issued by the government of Nagaland in the Personal and Administrative Reforms Department bracket Administrative Reforms Branch. List the matter again. When? Friday. Order, you get the order today, you get it on Thursday. Friday will be a bit, time constraint will be there.
One clarification I just want to get on. Kindly see my mission page 39.
What is there?
My name is Israel number 6 person.
Hmm.
And one Shri Kumar Tamang, Kalasik, is also Kalasik.
Hmm.
And now, worship, kindly come to the documents which are furnished, page 5. RDA. Documents furnished to RDA, which 5 worship. Last page. Serial number 38. Kumar Tamang. Designation has been shown as to be right. So, the authorities use the designation according to this logic, it should be Kalasi. Doesn't take against all this most commander group key posts, which is represented as NDAs. Number 38 should be Kalasi impact motion. As per the government's available text, page 39 of the petition. Kumar Tamang Kalasi, all being recognized in order, it has been shown up to be right. What was the Kalasi? Kumar Tamang, who was holding the books of Kalasi, has been declared against a juvenile post motion. It is not that Kalasi should be recognized against the boss of Kalasi. I'm submitting this on in terms of the available reports furnished by the authorities.
What is this annexure B? What is the beginning?
Russian.
Page 4.
Yes.
What is the beginning? How does this list come as annexure B? Annexure B of what?
Information furnished by the authorities through RDI.
Xerox copy of page 38. Oh, Xerox copy of 38 pages. Okay, page 2. This says annexure B.
Nature A entry. Nature is based on the order of means this. Double my solution is it is not the Kalasi, which is just nice to be recognized against the negative course of Kalasi. It may be recognized in any of the great reports. As has been done in the state of Australia over 38. Kumar Tamang who was holding the votes of palace has been regularized against the votes of Trinity. Therefore, the submission made by my learned very prominent advocate is not going to record this notion.
Anyway, let her get instructions. You tell us regarding the vacancy position, okay? Yes. We'll have it on Thursday. Okay. Please make one more sentence. A copy of this order be furnished to Ms. Bichano, London Government Advocate, during the course of the day to enable her to obtain instructions. This is the matter again on Thursday. Give the date.
For admission, item number 14.
Yeah, this is the one you say.
Yes, my lord, as per report, I think this is the meeting minutes out of 10 to you lost my guys the last part of power one and two.
What was this meeting about?
So my lord, here, the deputy commissioner has convened a meeting of all the parties involved in this case. And it was held on 10 January 2026. And after deliberation of the matter was again forwarded to the restaurant number 4 to decide the matter within 50 days. Or this will be my answer. And my lord, however, in the whatever decision has been taken by the restaurant number 4 has not been submitted. So still available. My lord, as per the paragraph, it says that the decision will be taken by the state respondent as per the decision submitted by the respondent.
What is the controversy here?
Your Worship,
Hmm.
here the petitioner was excommunicated without giving the opportunity of appeal.
Okay. Then against that you've come. Where's the order of excommunication? Anything? So some more time is required.
Yeah.
He's right. Mr. E. Tivapom, learned government advocate, has produced the minutes, the meeting minutes dated 10/6/2026, convened by the additional deputy commissioner Mogokchu. With the representatives of the Mangbetong village within single inverted comma, capital A, Khel Senso Mundang, and the petitioner. He submits that after deliberation, it was resolved that it was decided that the Rising Fund Committee, A Khel and Mangmetong A Khel Senso Mundang, to come up with a decision within 15 days from the date of the meeting to amicably resolve or settle the matter at the district authority level or to contest the case in the High Court. So that further course of action will be initiated after submission of the decision from the respondent Mangmetong A Khel Senso Mundang. The learned counsel therefore submits that, learned government advocate therefore submits that the matter may be taken up after the ensuing summer vacation to enable him to get the up-to-date status. In support of his submission, the learned government advocate has produced the meeting minutes dated 10/6/2026. The same is kept on record and marked as X for identification. Next, in view of the above submission, release the matter again after the summer vacation on a date to be fixed by the registry. The interim order passed earlier shall continue till the next date of listing. Okay, so whatever I said, that meeting minutes contents, it's here, okay? You can check from here. Like X.
For admission, item number 16.
Let's see.
Yes.
My name is a small matter also. I was appointed in 2017 as a computer operator in the Department of Employment, Skill Development and Entrepreneurship.
You will not file reply affidavit.
No, my lord, because I have gone through that, then I complete the
Okay.
necessary. Here, the issue is regarding non-payment of salary.
Non-payment of salary.
Yes, for 2 years. And also, I have already left the service and ultimately I was recruited as a foreign staff last year. Entire state recruitment process was conducted and then I was recruited.
Salary for what?
Salary as computer operator, I was appointed on fixed pay of rupees 7,000 per month.
Where's that appointment order?
Annexed to my law.
Page? You ready, Pijano?
Page 11.
Okay, page 11.
This is
This
was extended from time to time. And
This
then-
is your initial appointment order,
Yes, Lordship.
dated 18.
18th July.
18 July. You're appointed as what?
Computer operator.
Computer operator,
On
fixed pay of 7,000.
Yes, madam.
For how many years?
Then, Lordship, it was kept extending and then I served till 28th of February 2024.
20 February 2024.
Yes, my lord.
With-
Now,
Just a minute, with effect from, this appointment was with effect from 2/2/2007, correct?
yes, my lord. Will effect from 2/7/2017. 2017.
Or 17?
Yes, my lord.
7 or 17?
17, my lord.
17. Okay. Then,
Then my service has been extended, Lordship.
From time to time also. Now, if I look kindly go to an answer for this is important also because the affidavit is sworn, the state affidavit is sworn by the person who was still the joint director, who had issued one of my extension orders in 2022.
This is what, under the Directorate of Employment Skill Development.
Yes, my lord.
And what is this?
Towards the bottom of the page, also the issuing authority.
Entrepreneurship, okay.
Yes, my lord. To page 17, so forth. That's what it is.
Yes, page 17.
Yes, page 17.
It's not legible. You come to page 18. This is a type copy.
That copy is at page 18 to 19 also. So in page 19, the name of the third joint director appears. He is present the director and then he has sworn the affidavit filed by the state respondents in the presentation.
So?
In that, on two grounds, there are indirect payment of the salary. Firstly, the ground taken by the state respondent is that there is no government approval for my account. Secondly, in paragraph that is in paragraph 2. In paragraph 4 of the affidavit of opposition filed by the state respondent, they are saying that my paid score is unable to be traced. On those two grounds, my salary is here for 2 years.
What is the period? 2 years. For which period?
From March 2022 to February 2024.
And before that, you received?
Yes, before that I have received continuously. Now also the outstanding every salary is it stands at rupees 1,68,000. So Lordship, I have written a representation to the director Lordship of my department on 9th of April 2026, which I have annexed next 23 and next 6 in my the stand taken by the state respondents is that they have forwarded, the director has forwarded the same representation to the Commissioner Secretary of the Department, which they have annexed, the letter they have annexed, that particular letter is annexed at page 6 of the affidavit filed by the state respondents. The last page.
This is not disposed till now.
No, this is not disposed to the Lordship. The Lordship, the law is well said with Lordship that when Lordship in the initial appointment order, it is clearly reflected that I have been appointed against existing vacancy. There was somebody who had resigned, and on that one Mr. Muxtam, who left. At page 11, the type of is at page 12, the initial appointment order.
So, where is the appointment of that person?
The appointment of
Somebody was appointed, resigned, you were appointed in his
Yes,
place. Now, whether that somebody was appointed properly or not against a sanctioned post.
that also, if it was not the sanctioned post also, then I believe you will not be appointed against that particular vacancy. You may be appointed.
So maybe may not all that, we cannot go by that.
This person.
We have to be very precise.
Yes, person. Fact remains the person. My service has been taken by the state respondents. And when my service has been utilized fully, person, and at the penalty salary of 7,000 per month.
So let them
And it's also
consider,
not the case that I am.
let them consider your representation and dispose of the same within a time period.
Fortunately, in that case, strong belief that we should practice by a short time, the direction may be given, so that within a short period of time, my representations are considered. And on that basis, it can be disposed.
So we'll dispose it of.
My lord.
Heard, Mr. Sentianger, learned counsel for the petitioner.
In support of my case, my lord, I would like to press a short ruling also, very short paragraph.
And Ms. Bichano Lotha, learned government advocate for the state respondents. Stop having regard to the nature of grievance rejected by the petitioner. The writ petition is taken up for disposal. To stop. Next paragraph is the case of the petitioner that he was appointed on a fixed pay of rupees 7,000 as computer operator, while office order dated 18/7/2017, issued by the Director, Employment, Skill Development and Entrepreneurship, Government of Nagaland. Stop. The said appointment was made against the vacancy created by the resignation of the earlier incumbent. Stop. According to the petitioner, he has been serving diligently to the said post, in the said post.
Lordship, if I may, lordship, in the appointment order, it is clearly mentioned that his salary is attributable to the head of the account.
I've seen that,
Yes, my lord.
non-planned. He has been serving, what did I say? And his services has been extended from time to time. Then what happened? You resigned or what? You resigned.
Lordship, my service was not extended beyond 2024.
Where's that last order?
And it's a four also. An extra 5, my lord, I'm sorry. An extra 5 also. It's the that copies of pages 21 to 22, my lord.
Stop. According to the petitioner, the last extension given to him was White Office Order dated
4/3/2023.
4/3/2023, by which his service was extended for a period of 1 year with effect from 1/3/2023 to 28/2/2024. Stop. Thereafter, no, as there was no further extension, the petition served as computer operator up to 28/2/2024. Stop. According to the petitioner, despite having rendered his services, he has not been paid his salary with effect from March 2022 to February 2024, which has accumulated to a total amount of rupees 1,68,000. Stop. Aggrieved with the same, the petitioner approached the Director, Employment, Skill Development and Entrepreneurship, Government of Nagaland, by filing his representation on
9/4/2026, my lord.
9/4/2026. Stop. The said authority in turn forwarded the same to the Commissioner and Secretary to the Government of Nagaland, Labor and Employment, Skill Development and Entrepreneurship Department on 8/5/2026. For consideration. Were you aware about this prior to filing, before filing of the counter affidavit about this forwarding letter?
No, my lord.
You do not know. Stop. Mr. Sentianger, learned counsel for the petitioner, submits that since the representation of the petitioner was not considered by the director, employment, skill development, and entrepreneurship comma, he has filed the instant writ petition. Stop. However, after the filing of the counter affidavit by the respondent number 1 and 3, 1 and 2,
Yes.
the petitioner has now come to learn that his representation was forwarded to the Commissioner and Secretary to the Government of Nagaland, Labor and Employment, Skill Development and Entrepreneurship Department on 8/5/2026 by the said director. Stop. The learned counsel submits that the petitioner could not have been deprived of his salary, considering the fact that his appointment, although on temporary basis, was against the vacancy caused by the earlier incumbent, and the expenditure for salary is debatable. The expenditure and that the salary is paid. The salary is considered as a non-planned expenditure, as indicated in the appointment order. Stop. At any rate, the learned counsel submits that the respondents cannot deprive the petitioner from payment of his salary for the services he has rendered. Stop. He submits that the apex court in Mansingh versus State of Uttar Pradesh, through secretary and others, reported in 2022 SCC online SC 726. In the given facts of that case, held that even if the appointment of an employee is found to be irregular, the employer, the employee having discharged the duties has to be paid for the services rendered. Stop. He therefore submits that even if the respondent authorities are of the even if the respondent authorities are of the view that the appointment is irregular, they would still be liable to pay for the service rendered by the petitioner. Next para, having regard to the above projection and considering the fact that the representation of the petitioner is not yet considered and disposed of till date, the writ petition is disposed of by directing the
Director of
respondents. Why director? He has forwarded to the commissioner.
also.
By directing the respondents more particularly, there is no, okay,
This also.
commissioner is not a party.
This also. So sending the direction the country to the responsibility.
It cannot be. Respondent number 2 has received and sent it to the commissioner. Now, will he call back that and decide himself? This is the problem.
This also.
What is to be done? Which why the director is forwarded to the commissioner?
When you for the direction of the last paragraph, it is similar to the view of the above mentioned department, is the message to kind of take up and very personally and which we perform, we have the government selection.
It's complicating the things more.
This also. Not at this point, if the direction is finally given to the respondent, but the two and then if in future if any new cause of action arises, then we can approach this on the whole content by within the functioning secretary as well as the PMI department in the place. But that will depend on how the resolution is considered.
Who has filed this affidavit? No, we'll direct the commissioner on it. We'll do the dispose of with a direction to the, what did I say? The commissioner and secretary to the government of Nagaland, labor and employment, skill development and entrepreneurship department. To consider the representation of the petitioner and dispose of the same. By way of a speaking order within a period of 6 weeks from the date of receipt of a certified copy of this order. Stop. It is further clarified that although the commissioner and secretary to the government of Nagaland, labor and employment, skill development and entrepreneurship department is not a rate as a party respondent but the affidavit in the position of the respondent numbers 1 and 2. Shows that the representation has been directed, has been forwarded by the director of so and so to the commissioner and secretary. The order to be passed by the commissioner and secretary to the governor of Nagaland, so and so department, shall be communicated to the petitioner.
For admission, item number 17.
Yes,
The respondents to file. The basis for is the conversation is assessed by the degree commission. Degree commission for two. It's not dated the petition.
so what is the instruction?
Entering appearance on the day of.
Or?
They feel for.
3 and 4, who are they? Okay. Any information regarding the non-payment? Then what about the estate? Works and housing?
It was the. It's only. Not sure we do.
Mr. Moa Jamil, learned counsel, submits that he'll be representing respondent numbers 3 and 4. And since he has recently been given the brief, he would like, he may be granted 3 weeks' time to give instructions in the matter. Stop. Similarly, who's appearing? Zimami, Mr. V. Zimami, learned government advocate, also prays for 3 weeks' time to receive instructions and to file counter affidavit. The prayers allowed. List again after the ensuing sum of the patient on a date to be fixed by the registry. Respondents to file their counter affidavit by then.
For hearing, item number 31.
What is this matter?
The decision is the third party. The appointment of the respondent is. As of the NTS. It's a grass out of the original development. And we had a right for appointment on commission.
Okay.
Cases.
You are a landowner,
Yes.
and who is appointed?
Respondent six.
Not landowner. Who's appearing for respondent number 6? You are there.
Yes.
You have filed affidavit. And government? You are Mr. Longkumar, M. Longkumar. First of all, can you show me the policy of the government for appointment of landowner? Ah.
The policy that is more particularly the policy issued on 5th March 2018 to school financial.
It's challenged
Yes, sir.
because
Because Lordship, one of my
cousin has already been appointed. And he could not complete his period in his time. And again, the vacancy that I was on his back, I have applied in 2022. Now the policy of the state government is that in terms of the 5th March 2018, landowners cannot enjoy jobs, cannot give in perpetuity. So if I succeed in the challenge next year, I am entirely of the witness.
Okay, so show me that OM which you've challenged. Page.
This is page 20.
Page 20.
8. 2A.
So it is not legible.
Also, the tag copy is within 30.
Hmm.
Oh,
28A.
yes. Like this is the tag.
Which clause?
Whatever.
PC.
GC. That is, that is the one.
So you're challenging this 3C.
It is also clarified that it's not a policy of the government, but government should remain on it. You already engaged in that.
This is the first case challenging this
Yes.
3C.
This is the first.
No other cases there.
Yes, I
Government?
have not come.
No other case.
It will have.
Hmm. So why do you say that this 3C is bad in law?
Okay. I have really strong in my petition, starting from August 17 to 26.
See, because before that,
Yes.
17 to 26, you say. Before that, now what a little background of this policy of the government will be required to be understood.
Okay, this was a unilaterally issue. No consultations, the stakeholders were never consulted.
No, not that. I'm talking about the
Yes,
policy of the government to give appointment on the basis of land donation. What is the idea behind?
okay. In the past, prior to this.
Prior to this, definitely. Because out here, nothing is mentioned. It just says that once what a person is given, the second relative cannot take. That much only. Now, what is the genesis? Why?
That the government is the best to answer, but unfortunately, those have been affidavit. And negotiation filed by the respondent,
No,
nothing has been said about this.
you cannot give the entire burden to the government. You also are challenging this 3C. You are to satisfy the court. See, the very purpose of having this kind of appointment is for the benefit of the family who's giving land for free of cost. And if you give appointment to supposing Mr. A, and within 2 months he expires, then you say, no more appointment. Will it be fair? So you have to address the court in that line.
We have committed about 4 geometry in this case. That's about 7-8 acres of land.
No, that's okay. See, we're not concerned with the size. It may be very small plot, 50 by 50 by 50 feet. I have given that much. But a different thing. Only thing is that you have given the land free of cost, and the government has a running policy saying that whoever is donating land like that will be given the preference of appointment to a government job. And going by that, you have got the benefit of promotion of appointment to one of your relative, but unfortunately, he could not serve long. And ultimately, when the other person has come, the government says that no, you cannot because of this clause. So this clause is not, is arbitrary. It's against the interest. It's against the very concept of giving this appointment. So that way you have to develop the argument, na?
Sorry, the ground that I given.
But then you have not enclosed the earlier notification by which the what do you call, the landowners appointments are to be.
Specifically, just from history, there are some cases where there are agreements between the parties. And there are cases where oral agreements are made. In my case, there was an oral understanding. And it was done in the early 80s. In fact, that really opposite the present days was established in 1981. And it was there was this oral understanding between the landowners and the government department. In 2018, when we paid subsidies.
When was the donation given? Land?
Okay.
When was the land donated?
1980. And VOP was established in Iran.
What is the full form of VOP?
This is a veterinary of.
Oh, veterinary outpost. Who was appointed in this post against the land donation?
Look at the respondents.
In your family, who was appointed?
In 2006, one Chupa.
From your family?
Yes. In 2006, since 81, we have been demanding that the landowner should be appointed. But no appointment was made. We were never considered.
You can put off this fan, no? It's very noisy, no? Can't hear it.
And then only in 2006, one of my cousins was appointed.
2006. Then how long did you continue?
In 2020.
He was appointed as what?
Medicine carrier.
Medicine carrier in 2006. 2020 he expired. Then you applied for the post.
Yes.
Then
But,
you
because of the COVID, my first application was into the post office. Then in 2022, after the session COVID restrictions, I again applied, reapplied. Then my case was brought up by the directorate before the administrative.
Yes.
Department.
Then
I was hoping for a positive outcome, but out of the blue, the respondent number 6, she was fine. Now, on the filing of the contract affidavit,
how was she appointed?
no selection, nothing.
Okay.
Out of the blue. That's the big addition. She is not a landowner. She is not on condition. Now, by filing the affidavit, the government, as well as the private respondent number 6, you are saying that she was appointed in view of the relaxation in the dispensation of the selection process as contained in the memorandum dated 3/3/2022.
Where is that?
Not at all. It's in the government affidavit also. But
Show me that government affidavit. If it's there.
This is the second one we got.
No, just see the affidavit.
Page 23, as the chart.
Yes, it's here, 3323.
Now over here, is third March of 2022 memorandum is in respect of appointment on two grounds. Noted.
No, read,
Clause two.
no, read clause 2, please.
Following difficulties expressed by various departments and because of the fact that in many cases, group G report, such as prohibitions, monies, dues are filled by landowners and on commission ground. And locally, at the district subdivision or village level, the measure was considered by the unit in its meeting held on 9 February 2022 and 22 February 2022. In order to remove such difficulties, it is hereby directed to the condition of advertisement is dispensed with wherever such difficulties are faced by the department, as long as a fair and transparent eligibility criteria and process is followed, and in all such cases, approval of the government is obtained.
No, what is that difficulty?
Noted
What does,
the government has to respect. Though my recommendation is that my mayor explain. This memorandum and the dispensation of selection process in the advertisement is in regards to two conditions for appointment on commissioner ground and when a post is required to be filled up, not otherwise.
what do you mean by this? What is that difficulty?
Look, before I go to that motion first, I'll just note my submit that in my position page 2.
Mhm.
She stated that as far as the appointment on land ownership basis, not just one or two persons of the same descendants are on their leave. Anything, right? The next year.
Okay, that is another aspect. Okay, I think there are two aspects of the matter. One is going by that 3C or 2C, whatever the thing that in that landowners cannot claim appointment in perpetuity. That is one aspect. The other aspect is that without advertisement, you appointed somebody. Whether it's possible.
There's all this.
And secondly, if it is advertised, supposing, cannot the petitioner also participate openly? That I'm applying for this post not as landowner, I'm also a contender. My plus point is that I'm also a landowner, but I'm applying since there's an advertisement. And if selection was done and if the private respondent is appointed, then it's a different thing. But now, if there was no such advertisement and saying that this office memorandum permits us to appoint somebody, pick and choose, will it be fair? Just read, what does it say? What is this difficulty?
Yes. Lodging on this note on the last occasion, the same question was raised by the board. And they asked me to get instruction, clarification on 3 points. As the motion was mentioned just now. The first question as to the last order was whether why advertisement was not issued. Second was whether any selection process was completed. And the third was whether the petitioner saying that this point relates only to landowners and professional performance. So whether this only pertains to landowners or professional performance.
Which OM? This
This
3rd March.
Yes, that's what the petitioner said. So those were the 3 queries that we.
So what is the answer?
Yes, I received the instruction. I read it. Noted, this is what I have not been preliminary.
We'll do one thing. You file this waiver of an affidavit. You'll do better.
Okay.
So the other side also gets a chance to see what is what.
Yes, sir.
By which order was that query made? Because I went through the briefly and I found that something was required to be done.
Already 25, 5.
21.5. Okay. Okay, please write. When can you file it?
This is after the application for filing.
Mr. M. Longkumar, learned government advocate, appearing for the state respondent, submits that he has obtained instructions in terms of the order passed by this court on 21/5/2026. And that he would like to file the same by way of an affidavit. Considering the same, let the matter be listed. When? On reopening?
I will take it also.
So on the second week? I mean, 1, 2, 3, 4th week of July? List the matter on 21st of July. Definitely. List the matter on 21st of July, 2026. What was the last line? No, the last line only. Don't read from the beginning. That much. Twenty-first on July 2026. The learned government advocate shall file the affidavit on or before. When? On or before 17th of July 2026. And the petitioner may, if so advised, file a reply to the same. List accordingly. I think it should be listed on 23rd July, okay, not 21st. 23rd July. This is an interesting issue, but it'll have far-reaching consequences in other cases because I don't think. But it can go in two ways. One is advertisement. You also take part, not as landowner, but as generally.
In the present scenario, I was not in the class.
And the other one is the landowner thing, whether you can stop that landowner thing after one appointment. Because somebody may serve 10 years, somebody may serve 30 years also, we don't know. But tomorrow somebody may serve just 2 weeks. Then on account of some unfortunate incident, he expires, then what will happen? Can it be stopped? This can also be another, a factor. So that's why I had asked you in the beginning, what is the background and all that. So you should be ready with the background because the idea behind giving appointment on landowner basis is that government can acquire the land free of cost. In return, they will give back something to the family.
We are responding to this 2018. We are discussing with the acquisition of land.
Sorry. Okay.
What about that?